You have enough IRS jokes yet? We're going to exclude Joe from this one. What do you call 20 IRS agents buried up to their neck? Oh, good. You heard this one. Good start. Okay. 20 IRS agents skydiving. Skeet. Some of you are going, what's that? See, I can tell you from the city. You got to look it up in your dictionary when you get home. Well, I'm really honored to be here. I want to thank Payman and the Freedom Law School for putting this on. And we got such great speakers here. It's really quite an honor. Bill Benson. I want to thank Bill Benson because he paved the way for Joe Bannister to come as far as he did. And there's many of you members that I know in here, we wouldn't be this far without you. And some people say we didn't get very far, but I don't agree with that. I see a lot of things happening. We're going to talk about strategies, though. Some say you can't win against the IRS. We've won several times against the IRS. We also have a program to help keep people out of jail. When you talk about not filing returns, what does your friends and neighbors say to you?
Go to jail.
Yeah, I'll bring you cigarettes. And the sad part is you cannot even smoke in jail today. That would be a good time to start, maybe. So we're going to talk about a few cases. We have a legal defense fund, and the legal defense fund is not great. Payment really builds it up, but all it does is give us the money by working together. And this is important, that we work together. It gives us the money to defend cases. We cannot stop people from going to court if you're going to take a stand against the government, because the government's become the outlaws, in our opinion. They can charge you with anything that they want. The question is, can you defend your position? And we're going to talk about that in more detail on things that we do. I want to share a couple of cases with you because some of these can be funny in the arguments that they make. One of the arguments that we use in the California Franchise Tax Board, and by the way, they never lost a case until 1987, and we won 17 cases from 1987 to 1992. And their slogan used to be, we can't win them all, and now the best they can do is, well, we can't, no, I'm sorry. We never lost a case used to be their slogan. Now the best they can do is, we can't win them all, which is a better slogan. But some of you may know, if you watch Perry Mason, that you have a right to competent counsel. Anyone heard of that? Or counsel? We take that a step further. We believe you have a right to competent counsel. Is there a difference? If you look around for an attorney to handle a case against the IRS, you'll find a lot of them want to take the case. They'll say, yeah, sure, I handle this thing all the time. Give me $50,000 and don't worry about it. And that makes you feel good, and you can go home and sleep good for the first time in weeks. Well, you should ask that attorney after you give him, or before you give him the $50,000, say, do you think we're going to win the case? What do you think his answer is going to be? No. Generally, it's going to be, no, of course not. You know you're required to file and pay. Is that competent counsel? No. Or he may say, yeah, I think we can win, and then you might ask him, well, how many have you won in the past? Well, none yet. So that's the beauty of these meetings. And I think a lot of you probably can figure this out without help. You can probably figure out how to lose a case without spending any money whatsoever. But anyway, what they do, and this is really a game they play, because failure to file cannot be a crime. Because when you are accused of doing a crime, then to commit a crime, if you look up the word commit, it means to do something. But yet, what the IRS charges you with is doing nothing. But not just any nothing, you're doing nothing on April 15th. And most Americans believe that this is a crime, punishable by jail, don't they? And then they'll read about somebody in the paper around this time of year. Well, look, so-and-so was charged with doing nothing. We better not do nothing this year. And then they'll tell their friends and neighbors at work, oh, look, don't do nothing this year. You'll go to jail. That's silly. And if that it can be the way the law works in America, what else are you not doing? But anyway, we take competent counsel. So in the state of California, we can't find competent counsel, amazingly. So what we do is look for competent counsel, and we have the member go in, and every time he goes before the judge, he shows him that he checked with so many attorneys, and these attorneys either cost too much or said they would lose the case. So we ask for another continuance, and we can do this. As far as I'm concerned, indefinitely, but the court gets upset eventually, and we've done this as long as a year, I guess, in some of these cases. Just go in once in a while and get another continuance. The judge finally gets upset with a person, and he'll send you through trial without you waiving counsel and without you having counsel. In California, this is an automatic reversal on appeal. Now, some of you think, well, they're going to appoint counsel. Well, they tried to do that. And the trick is you cannot fire appointed counsel, then you lose your right to counsel. So we go in and show the public defender's office what their case is going to be, how many weeks they're going to have to spend on it in trial, and the issues. And generally, they take themselves off the case. And that preserves your right to counsel. So we had 3 cases overturned on that right to counsel in California. We had a case in Stockton, a couple of them. One lasted, these are misdemeanor cases also in California, which is the same as not having a driver's license. They're not really serious crimes to begin with. Tax evasion, some of you may have heard of this charge. That is a felony, and it's a form of perjury because you're lying under oath on the tax returns. I know some of you think perjury is not a crime anymore after the impeachment. But believe me, probably for you and I, it still is a crime. We had two members in Stockton charged. It was one of our earlier cases. We did get a conviction in the case. We were planning on appealing it, and the members decided not to. But it took so long, so many years to get that conviction, the district attorney in that county said, I will never take another failure to file case again. And he hasn't. The public defender's office, which helped us on that case, even when they had cases come before them on the franchise tax board, they even said, well, you know, I don't know how to handle these cases very well, but I do know an organization that does, and the public defender's office in that county was sending them down to Free Enterprise Society. Now, some of it's a simple burden of proof. Here's something we did that was kind of neat. You know, when they have to prove that you commit a crime of doing nothing. They have to prove that you're a real bad guy when you did nothing in front of the jury. So what we have to do is let them have the burden of proof. They have to prove several things. They have to prove that you intended to commit a crime when you did nothing. That's called intent. They have to prove that you had a filing requirement to the jury's satisfaction. They do that through checks or W-2s, that kind of thing. Prove that you worked, basically. And they have to prove a third thing, which a lot of people don't let them prove in court, and they have to prove that you did not file. Now, if you don't get up on the stand like a lot of people I've seen do you file returns? No, I didn't, and I'm proud of it. Because I learned the law and I'm not required, you know, whatever. Well, that's really a big portion of the prosecution's case. Is it your duty to prove yourself innocent at this point? Or do they have to prove that you committed this crime when you did nothing? Now, this is very interesting. Now, what happens if you don't admit that you did not file? How are they going to prove that you did not without your help? Well, they're going to bring in a computer expert that says the computer shows no return filed. Is that proof that you did not file? No. Maybe I mailed the return and maybe it got lost on the way to your office. Can they say no? They can. Well, that could have happened. What do you do when you get it? Well, we type it on the computer. Well, maybe you typed it on wrong. Could that have happened? Well, yes, that could have happened. And on you go. We can go through 100 different things on the fact that you could have filed the return. This, ladies and gentlemen, the government put themselves in a position, if we let them prove it, is proving a negative. Anybody know what that is? It's an impossibility. So we got a not guilty verdict in a case. It was our first jury acquittal in California on the Franchise Tax Board. No, it wasn't our first, but it was one of the cases on the Franchise Tax Board. And the jury thought the person was required to file, and they didn't approve of not filing or doing nothing, but they did say the prosecution never proved that he did not file. Not guilty. We had a case in Michigan, an IRS case. They did not get him to trial in 70 days. That's a speedy trial violation, game over. Would that bother you to have that kind of case? See, some people say, well, you're not getting the issues heard. Why aren't we bringing these issues into court? Well, we're not going to get a lot of those issues heard, and so, as you heard, there are people like Conklin and Holland really taking these issues through and know how to do it. But for the average person, you know, what I can tell you, and you'll like this, I mean, I'm not correct on everything, but you can count on this. You know, if you don't go to trial, you will not lose the case. So if we can get it dismissed before trial, we'll do that. And you'll be a happy camper. We had another case that the Legal Defense Fund was involved with, and in Kansas, the IRS agent and the district attorney lied to the grand jury to get the indictment against the individual, and that was uncovered, and the judge threw out the indictment. Game over. There's another one, venue in California. Anyone know what the venue is in the Constitution too? Venue goes to the very heart of someone to sit in judgment on a case. If the complaint is filed in the wrong place of venue, then the case is void. So what does they do when the Franchise Tax Board comes and gets someone for failure to file? They charge you in the county in which you live. What county are we in here? Orange County. So the Franchise Tax Board would file, the district attorney in Orange County would file a complaint. But yet, you know, in this county, there is no law requiring you to do anything with the Franchise Tax Board in this county, is there? Can you file a return in Orange County? You cannot. Where is the returns filed at in California?
That's so long, I don't know.
Sacramento. Even Franchise Tax Board will tell you that. If a crime indeed was committed, I contend it's Sacramento. Now, if it was failure to mail the return in, they might make a case for Orange County. Now, we modeled and learned this information from the Attorney General of North Dakota. In previous cases, we had argued venue just the opposite of what I told you, and the Attorney General of North Dakota corrected us. And we used that to model our venue argument in California, and many judges and attorneys really admitted off the record that we're correct. And what happened in a few cases, we had 3 cases we contribute to venue. One was moved twice, not to Sacramento, but moved twice, and the third time they never set another trial date. After a year, that's dismissed. We had another case in Stockton. It was a felony case. It was our first one we put in. This was kind of funny to watch these guys, because they didn't know. They looked at the argument, and there was not many people in the court. We had people watching our member there. And it was in Superior Court because this was felony. We weren't in the municipal court. We were in front of a state judge. And pretty soon another state judge came through and went in the back. He called a recess. And then another state judge came through and went to the back. And then they would peek out once in a while, look at who's in the audience. And they came out, and to make a long story short, they dismissed his case altogether and said he was denied counsel at a probable cause hearing. Now, this is something prior to trial, and we've been denied that before and never got a dismissal. We believe they were trying to avoid the venue argument. In another case in Stockton, the Attorney General, remember these are misdemeanor cases generally. This one in Stockton was a misdemeanor case. The Attorney General sent one of his assistants down to prosecute this misdemeanor tax case after we put the venue argument in. Do you think the Attorney General is concerned about the venue argument? He is very concerned. And here's his argument. It was good. Yeah, listen. The Attorney General, Assistant Attorney General said, Your Honor, it looks like the legislature has given us a problem here with venue. He's trying to blame the legislature for the error. But indeed, the only one that erred was the district attorney in San Joaquin County by filing the complaint. He had no jurisdiction to do that. Now, to this very day, even though we virtually got admissions that were correct, they still file in the wrong county venue in California. Why do you think they do that? They don't want people to know. You see, the first time they move a case to Sacramento, what happens? How many cases, remember what I told you about venue, how important it is? If a case is found to have maybe improper venue altogether, that case, period, is in jeopardy. Okay? So if they move one, how many cases in this state have been filed in the wrong county of venue? Many, except for those in Sacramento. So they open up a can of worms. Now it becomes a political problem, doesn't it? had one member he filed returns, and we had a member charged with failure to file. Most of you think if you file returns, you're safe from that charge, I'm sure. But yet sometimes that still happens. When a member charged, he filed a 540 form, a modified one. It wasn't exactly what the state wanted. And they charged him with failure to file. But you know, their records, and we proved this through the Public Records Act, which many of our members are doing. That's a State Freedom of Information Act. We proved that they showed that on their computers as a return up until 6 weeks before trial. At that time, it was removed so they could do a search 5 weeks before the trial to show that no return has ever been filed. These kind of things are very helpful in front of the jury. And that, yes, did result in an acquittal. His wife was charged through community property. Anyone heard of that law? Kind of little-known law in California. You know, your spouse may get half the property, but your spouse also gets half the debt. Or in this case, they even charged a spouse criminally through community property. And we handled actually a couple of these, but I want to explain how this works. You don't have to file these with the county or coroner generally. They're available through our organization. A lot of our members have done these. But they charged the wife with failure to file income tax returns. In this case, she never worked outside of the home. She never had anything to do with the finances or the tax returns. But still, they tried to put her in jail. Now, the tactic here is pretty low down. Obviously, they're attacking the wife to get the man to cave in, or vice versa sometimes. But it's holding your family hostage, in other words. Only the lowest and dirtiest do this kind of tactic. So here's the Franchise Tax Board. They must qualify. But anyway, what we had to do, and this is the trick, you don't go in right with the community property agreement right away. What we had, the agent that made the complaint, we had them on the stand, and you question them until you get them to admit why they charged the woman. Finally, they get down to it after trying to avoid the question. The only reason she was charged was through community property. Once that was admitted, we could bring in this community property agreement that we have that separates the community, and that ends the case for that woman. The judge says that's a legal document, and the jury acquitted her very easily. We had another spouse on the same type of thing. We can avoid a lot of these problems by being smart, like a lot of the speakers are talking about. Now, I know my time, they didn't say anything, but my time is probably going to be a little short because we have a banquet coming up that they have to set up for. But I want to go through a lot of cases because there's a saying out there, you can't beat City Hall. Who in the heck started that stupid rumor? You betcha. Tenacity is half the battle. Having the money to defend is another problem, and we solve that through our membership a lot with our legal defense fund, which I hope to get to here in a little bit. But if you're new to the income tax, we have a seminar on the back table in this little envelope for $15. It goes through all the basic problems of the income tax and some of the things we're doing in our membership programs and things that we have, and that would be a very good thing to pick up. But you'll admit, since this meeting has, I don't know, 300-400 people here, we should be doing meetings in the stadium here. L.A. Ram, whatever the football stadium was. We should be doing 70 or 100,000 people. Now, why we're not is because of fear and ignorance. Which one's worse? Yeah, I don't know and I don't care. Just get out of here and leave me alone is most people's answer. You're going to think I'm weird, but I want to talk about stuff on other people's tables because there's a lot of good exhibitors here. One of the things that I have come across 10 years ago, this was not widely available to the public, is a course by Cleon Skousen. And it's over here on the table, Miracle of America. It is the best course in this country that I've ever seen on the Constitution and history in this nation. I took the course, and it comes with a bunch of videotapes and a very professional workbook. This was the official law. This used to be the official course in this country. In fact, they still teach law enforcement and elected officials that are interested. They teach judges that are interested. Sheriff Richard Mack, some of you may know that name, who went to the Supreme Court on the Brady bill and won. Pretty good decision. He went to this very course himself. This is now available through another company that's a little multi-level. So not only can you educate, it's on ourselves to teach ourselves and our children and others to get them educated. That's all there are others to it. But it's you might get some information over there sometime during the weekend and see what you can do on this. If you're interested in the marketing, they do not require Social Security numbers for you to help others learn from this. So many of you might find that interesting because then you're doing something also to help America. Education is the key. Because as you know, and many of you know, knowledge overcomes a lot of your fear, doesn't it? Anger. Well, I want to talk about a program now. We put I don't know any way to stop them from charging anybody. Like I say, they can charge anybody with anything. If you take a politically incorrect position of maybe not filing a return, they may come against you with a charge called failure to file income tax returns, which you've heard of by now. And they do that out of this little book here. This is called the Internal Revenue Code. Anyone seen one of these? Anybody have one of these? You do? Admit it, sir. It takes a sick mind to read one of these, doesn't it? What do you do? You keep this in your bathroom for recreational reading and your friends? Now, I know you don't have these, but this has really been pretty useless in my opinion. Some of our paralegals like it better, but we have recommended the houses up in Clovis. I know you don't have those here, but this still can serve a very valuable purpose for you. That's good. We put a 4-step program together. When they actually charge you, your trial is over, in my opinion. And you might think, well, gee, the law is so clear. Just have Bill Conklin come talk to the jury, or Vern Holland, or Steve Hempfling, or Sean O'Connor, or Bill Benson, or anybody come talk to the jury. Do seminars. I think that would be great. I'm sure everybody here would want to do that. But the problem is, when you get in front of that jury, you know what? You cannot talk about the law in front of a jury in a court in this country today. And I know I can see a head shaking. Some of you don't believe me. You're just going to have to attend a trial someday. And they have a good reason for this. Here's what the judge, basically the instructions are. And they will say to talk about the law in front of a jury might tend to confuse the jury. I think they're exactly right. I think you'd have to agree with that reasoning. You know, if we could talk in front of the jury about the fact there's no law requiring an individual to file a return, that might tend to confuse the jury in a failure to file case. All things being equal, I don't think we would ever lose a case, but they're not equal. Because here's what the judge does do. He says, he instructs the jury, he's there to accept the laws. He gives it to them. Anybody been on jury duty? Yeah. You can confirm that. That's what they tell you, isn't it? In some cases, they really go pretty far in their jury instructions, almost saying, well, you have to bring in a guilty verdict. And then if you're listening close, and a lot of people miss this, he puts a disclaimer at the end. After he goes through all this and tells you what you can and cannot do, right before he sends you to the jury box, he says, don't let anything I say influence your decision. So he's telling you right there, you can disregard all of his instructions. And Fully Informed Jury Association, of course, already knew that. So you might pick up some stuff from them. So when we get in front of a jury, the strategy has to change. Some of the issues that you think you know, and probably do know, aren't going to do well in front of the jury. There are some I think there's merit to a lot of these arguments. You've heard the word sovereignty bandied about quite a bit. There's a state citizenship. You know, there's a lot to look at on these things. Or, I'm not a United States citizen. Okay? I'm not criticizing the things, but let's go in front of the jury. How many average jury members have an IRS code in their bathroom, do you think? See, not many. So when you're in a jury case on failure to file, you're a loser going in. They may be envious of you. They may wish they had the courage to do what you do, but they're mad at you. And you're guilty because they know there's a law requiring them. So we have to overcome that. But bringing things they don't understand does not help. Some of those arguments are so hard to understand, I don't understand all of them today myself. So what you do, if you jump in the stream, so to speak, with the jury's thought process and swim upstream, they're not only likely to convict you, they're going to commit you for psychiatric evaluation. This has happened. One of our members was taken to Springfield, Illinois, the federal place where they do this kind of mental evaluation. One person who's now a member in Reno, he was put in psychiatric evaluation. He was determined to be absolutely insane when it came to income taxes. And everything else, he was considered sane. And he has had no income tax problems since then. It's the silliest things that they're doing. But see, obviously what they're doing, and the reason this room isn't that big, they're doing it behind the curtain, aren't they? Like the Wizard of Oz. But what I'm doing, and all the people here doing, and we have to do it together with all of you, we're going to pull that curtain back. And Joe is going to be a big help in that. Joe Benson, we're going to meet tomorrow. So we're going to pull the curtain back. But anyway, your trial starts now. We're going to talk about things that the jury believes they understand. One of those things is the 16th Amendment that Bill Benson talked about. That is still taught in the school systems today. Anybody can verify that? Yeah, the IRS is a special guest speaker to public schools talking about the 16th Amendment, how it's the law, and it's going to require you to file, and what an honor it's going to be for you boys and girls to get up and work and pay your fair share. And the kids get real excited. They can't wait. So they use the 16th Amendment against us. So the books on Bill Benson's table, I think, are absolutely crucial. We're going to talk about these. This is a very, very good defense for you to have. Because anybody on that jury that knows what the 16th Amendment is at all knows that is the supposed income tax amendment. So now we're in the stream with their thought process on what they believe the law to be. Even though they've never really seen it or probably read it, they kind of know something's there. So I'm not going to go into detail what this book covers because he's done that already. Now, Bill talked about his trial and some of the comments of the judge. With the help of Bill Benson, in fact, we brought him out from Illinois more than once. We got a Reliance package. He's got on his table over there. This is what happened to Bill and others since the publishing of his book. All the tax groups in 1986, or 1985, 1986 were behind the 16th Amendment. That was their Achilles heel, we believed, and I still believe that it is. So it went into the courts. Well, why didn't we win? And then it went into the appellate courts. Well, I don't think we made a mistake, but we kind of assumed that the most intelligent legal minds in our country could count to 48. And that is how many votes it took for the 16th Amendment, to count the yes and no votes. That's really what we wanted them to do. The Ninth Circuit Court of Appeals right up here over California said this is a political question, not one for the courts. It would not count the 48 votes. That Ninth Circuit decision's in here. Another circuit court said, we don't want to embarrass another branch of our government. So they did not rule on it. Another circuit court said, it's been in use 70 years, the 16th Amendment. Maybe it's custom and usage. Can fraud be grandfathered in? It cannot. And we picked a lot of the transcripts. Bill's case is one of the most interesting ones you could ever read, and the transcripts from his case are very, very good. Judge Plunkett was the case, and I don't even know if he read this because I had to sneak out for my lunch. But here's a very important thing that the Judge Plunkett said on the record twice. He says that's not the point. The point is if his thesis is correct, there was no law to violate. He's saying on a transcript, and Judge Plunkett read this book. He said if Bill Benson's right, there was no law to violate. Bill Benson would not be here in this defendant's chair today. We would not be having a trial against Bill Benson. Failure to file wouldn't even be a charge. And we want the jury to hear that. That's going to be good. And there's some other interesting tidbits in this package. Now, normally, these are $250. Bill has a special today for $200, and you can even hold it. Like a $20 or more deposit will hold that price for you. And these are copies of certified documents from his file in Illinois. Bill Benson personally signs and seals each one of these books that these are copies from his certified documentation. His transcripts alone, ladies and gentlemen, were over $20,000. You don't want to have to spend that. So this is well worthwhile. This is step 2. Now this sounds pretty good unto itself. But they put this argument away. That's not good enough. Because they have a new jury instruction they made just to defend this. And this is what the judge will say, if this is all used. He say, ladies and gentlemen of the jury, disagreement with the law is not a valid defense. Alleging the law does not exist is disagreement with the law and therefore not a valid defense. Now, you have to think about that a little bit because that's pretty frightening. What other charges could you be made against you that don't exist? And if you try to talk about the fact they don't exist, they're going to say you can't do that. You could be charged with a lot of different things, couldn't you? Well, step 3. The courts won't answer us. One of the things the Ninth Circuit Court of Appeals said is petition Congress. Petition Congress, the Patriots did. That petition is in there, that package right there. Congress wrote back and said, we disagree with the Ninth Circuit Court of Appeals. We believe the question of fraud is one for the courts. That letter from Congress is in this package. All this is 1986 or before. The Supreme Court, when different circuit courts have different opinions, like they do on the 16th Amendment question, have always automatically taken the case until now. The 16th Amendment has sat there since 1986, and they're probably never going to take it. To me, this is proof that it is their Achilles heel, and maybe the 9 justices on the Supreme Court know how to count to 48. So where do we go from here? Step 3 of our program, and you'll see that we have a little catalog. I didn't bring it up here. It's a free package back there that goes through that. And the basic seminar I talked about goes through this as well. Step 3 is a redress of grievance. We're going to write our congressmen. This comes out of the First Amendment to the United States Constitution. And by the way, this is something I forgot. This is a serious, serious violation on my part. Free Enterprise Society mostly is concerned about this little document right here. It's called the Constitution of the United States. In this little book, which is on our table, also contains the Bill of Rights, Declaration of Independence, 10 Commandments, and for comparison's sake, you have the Communist Manifesto in here, which things that we're not supposed to be doing, which you'll find of interest, since we're following most of those items. This is the rule book, ladies and gentlemen, that made America the greatest country this world has ever seen. By following this, we became financially, industrial, and every other way superior to every other country. Your individual freedom and liberties came above that of the government and the masses. When people tell you this document is obsolete, which they're doing today, they're saying your individual freedom is obsolete. So don't buy into the argument. Now, if you don't have one of these before you leave, shame on you. They're like $1. I've seen them for $1. There are $2 on my table, 5 or more for $1 a piece. And if you've already spent all your money, I've had people dig up change for me already. So if you already spent all your money and you did not get one of these, I want you to go to my table and steal one. Do not leave here without one. It's okay. Don't go to Jack's table and steal one. Go to Free Enterprise Society's table right back there, and you're welcome to it. This is very, very important. Okay, anyway, step 3. We're going to write our congressman. Now, you have a really great senator down here, boxer. When you bring a constitutional violation to her attention, she will sit up and take notice. She'll probably ask you to come over for dinner to discuss the problem. That's not going to happen, is it? Well, this is part of our political process the founders gave us. This is another thing that the jury may understand. This is similar to a boycott. It's part of our First Amendment protected activities, such as attending a meeting like this. All of you are exercising your First Amendment right by being here. In many countries, they absolutely cannot do what you're doing here today, period. And if you want to prove that, let's try to do a rally in Iraq. Anyway, you're going to get letters from these congressmen, and they can be helpful. President Clinton wrote one of our members. He said, "Thank you for bringing this to my attention. I have given it to the Justice Department so that it can get the attention that it deserves." Yes, Janet Reno was very impressed. But you know, it's all right. Some of you are saying, I don't want that to happen. Ladies and gentlemen, these are your birthrights. These are your rights. They have no right to take them away from you. You're giving them up voluntarily. The only way, the law's on your side every way that we look at it, ladies and gentlemen. We're going to get these rights back by going at them straight away. Not hiding behind trees. So you don't need to worry about that. No one's charged that person. Justice Department did exactly nothing. Now, some of you are thinking about the Bruce Shaber case. I know that in here because there's a lot of very, very smart people here. Bruce Shaber was a Supreme Court case right after the 16th Amendment that said 16th Amendment gave Congress no new taxing power. Anybody thinking about that case? Okay. And based on that, thinking about that case, people have said Free Enterprise Society don't know what we're talking about. That's a worthless argument because the Bruce Shaber settles this. Well, here's the problem with that. The jury over here, how many people you might have on a jury read 1916 Supreme Court cases? Not very many, probably. More than likely, none of them. So you can bring in the Bruce Shaber case if you want, and we try to do this and try to hang our hat on that. And what the U.S. Attorney would do is bring in a Lucky report. It's a Library of Congress document written by an attorney named John R. Lucky, which Bill Benson has personally met. And it says the 16th Amendment is the basis for the income tax. It contradicts your Bruce Shaver case. Now, the jury, what do you think they're going to believe? They're going to believe the U.S. attorney in the nice, shiny new document. And they're going to assume Bruce Shaver's been overturned, even though it hasn't, and no evidence was presented showing that it was, because they've heard of things like this happening. That's just not good enough, in my opinion, because they believe it is the law. And it's hard to get that across to the jury in the way you like. Anyway, we do these letters. Another problem is we don't check with counsel or attorneys. Now, there are some reliance letters out there, and I think Joe Bannister is going to be doing one, probably be talking about it. That's going to be a very fabulous letter to have, because I think he could be considered an expert witness. So, but besides that, they'll get you on the stand and say, Mr. Jones, did you check with an attorney when you got married? Well, yes, I did. Did you check with an attorney when you got married? Oh, yes, I did. And then they'll say, did you check with an attorney when you decided not to file returns? Oh, well, no, I didn't. And you feel kind of proud of that. Why? Because when you learn the Constitution and your rights, what happens to your opinion of attorneys? It deteriorates, doesn't it? And you don't want to check with an attorney ever again if you can help it. You find out in this little book that you have all the rights and the power to make decisions for yourself. You are free in this country, unless you hurt someone else. I have. Okay. Number 4 is a lawsuit in the federal court under declaratory relief where we ask the judge, and now the judge is required to say what law we're required to file under, and he can't do it. I'm running out of time, so I'm going to go real fast on that. It's a 4-step program, and if you do this, and you need to do it now, not later. If you're a non-filer, this is something you should be doing. Because if they charge you for this year, we're not going to be talking about what they're doing in the future. We're going to be talking about what you did this year. So I'm going to wrap this up here real quick. We have more information in the seminar. We'll go in detail on that 4-step program. This is the closest thing that I know of a failure file win kit. Because we can't stop them from charging us, but we can make a defense, and you can give us a foundation that we can really work with. Within our organization, Free Enterprise Society, we have applications in the back. We have support programs that help you respond to letters to the IRS and Franchise Tax Board. We work with people around the country, including many of the speakers that you see here today. And what Payman talked about is we have a legal defense fund. One of the problems with getting charged in the courts today is they're very expensive. I had people, one person in my office spent something like $70,000 to lose a trial. And that did not include the appeals cost. That's a lot. That person probably wished he had spent nothing, saved us $70,000, and figured out how to lose the case himself. Maybe he would have spent a little time in jail, but he'd have $70,000 when he got out. Instead of the attorney being in Rio or somewhere. But the Legal Defense Fund gives us, by working together, and if you're a non-filer, you really should be in something like this. It's $850 to join the Legal Defense Fund back there, and up to $300 a year, and that gives us the money to put on the few that get charged, because they don't charge very many. And we haven't had any new cases for several years. That may change any time. And it's real cheap protection for you, if you know anything about legal cost. And we do take the appeals. We've taken appeals. We've had writs to the California Supreme Court. We've even taken things up to the outside of the California. We've even had writs up of the U.S. Supreme Court. And that's all included in that price that I gave. It's ridiculous. And the only reason we're accomplishing that and getting, I didn't go through all the wins. We have like 25 wins through the use of that Legal Defense Fund. We don't win them all, but we're winning about 2/3 of them. And that's very good. But having the money, without the money, what happens? We lose. I guess I don't have time for questions right now, but we'll be in the back. I'll be in the back the rest of the meeting and tomorrow. I appreciate your time, and I hope to talk to all of you. Thank you very much.